In a recent turn of events, the spotlight has once again shone on Pauline Hanson, the leader of the One Nation Party. Following a controversial ruling from a federal court, the court found that Hanson racially vilified Green Senator Mehreen Faruqi when she infamously told her to piss off back to Pakistan in a tweet. This incident was a part of a broader debate about freedom of speech and the implications of Australia's racial discrimination laws, specifically Section 18C of the Racial Discrimination Act. The context of this exchange began on the day of Queen Elizabeth II's death, when Senator Faruqi expressed her inability to mourn the passing of a leader she deemed emblematic of a racist empire. In response, Hanson launched a harsh and crude attack, which led to a court ruling declaring her comments as unlawfully discriminatory. The court described her remarks as seriously offensive, and noted that they embodied a strong form of racism. This brings us to a crucial point: the right to offend. While Hanson's comments were indeed rude and disrespectful, the question arises as to whether such rudeness should lead to legal repercussions. Critics argue that Section 18C is overly broad and stifles political expression. In contrast, supporters claim it is necessary to protect individuals from hate speech and discrimination. The irony is stark. While one can insult individuals based on their gender or political views without legal consequences, doing so on the grounds of race or ethnicity can lead to court action. It's essential to recognize that the law is not a tool for civil discourse. Legal repercussions for offensive speech may not change underlying prejudices. On the contrary, criminalizing such expressions might further entrench these views, pushing them underground rather than addressing the root causes of racism and discrimination. Hanson has vowed to appeal the court's decision, arguing that it infringes upon her freedom of political expression. She believes that her comments were relevant to the discourse surrounding the Queen's death, and that the legal finding represents an unjust application of the law. Her critics, however, view her appeal as a deflection from accountability for her inflammatory rhetoric. In a diverse society like Australia, it is imperative that we navigate the balance between protecting individuals from hate speech and preserving the freedom of speech. This case underscores the need for robust debate about the limits of expression and the responsibilities that come with it. Whether you agree with Hanson's views or not, defending her right to express those views is fundamental to maintaining the principle of free speech in our democracy. Ultimately, the outcome of Hanson's appeal could set a significant precedent for how freedom of speech is interpreted in relation to race and ethnicity in Australia. As this legal battle unfolds, it serves as a reminder that the right to offend is a cornerstone of a vibrant and democratic society, one that values diverse opinions and encourages open dialogue, even when the conversations are uncomfortable. Stay subscribed for more videos.